everyone. Welcome to LexTalk, World Talk Show presented by Clickaway Creators. Today we have Mr. Adnan with us. He completed his LLB from University of London with first class in 2007 and his Bar Vocational Course from BPP Law School in UK in 2008. Mr. Khan Khalid Adnan was called to the Bar of England and Wales from the Lincoln's Inn. Since 2009, he started practicing law in Bangladesh, and in 2013, he got enrolled as an advocate of the Supreme Court of Bangladesh. Barrister Adnan is the managing partner and head of the chamber of Khan Saifur Rahman Associates, and his areas of expertise are criminal law, judicial review, tort law, including road traffic accidents, and clinical negligence cases, including real estate law, corporate law, arbitration, and mediation. Hello, Mr. Adnan, how are you?
I'm fine. Thank you for inviting me to the show.
Pleasure is all ours, Adnan. We're really excited to know about your journey as a legal professional so far. So, can you please touch light on that?
Yes, when I talk about my journey, a journey means like where I was and where I am today. And the journey has been tough on many occasions, but like I would try to make it as brief as possible. I completed my schooling from Dhaka, Saint Joseph High School, and then I completed my college from Northern College in 2004. I was from science background, so like I was not into law, but my father was a senior advocate of the Supreme Court of Bangladesh. So like when I was like thinking of like pursuing my higher studies in science and in particular in physics, my father told me like, why don't you think about studying law? And like that was a big thing for me because like I wasn't thinking about studying law because like since my childhood I was a bit like introvert, and I saw my father being extrovert and like dealing with people and like dealing with clients in various ways. So like it was a difficult thing for me to decide what to do. Then my parents, they like insisted a bit on me studying law, and then I thought like, okay, like this is what my parents' dreams are. So far as I'm concerned, like let's take a shot. Then I started studying law since 2004 and 5, and I got enrolled under the University London distance learning program. And it was difficult for me in the beginning to cope up with law, like having come from a science background. It's difficult because like law is basically a subject in arts, and science is like basically a different topic completely. So like I was having a problem in like developing my thought process. But in 2007 I completed my honors from University London with a first class, and I got their best student award for 2 consecutive years in 2006 and 2007. So like by that period of time, I started to like feel like, okay, I'm getting what law is, and I'm getting what this profession is all about. So like in 2007, I went to do my bar from BPP Law School, and in 2008, I completed my bar from like BPP Law School, and I was called to the Bar of England and Wales in 2008 by the Honorable Society of Lincoln's Inn. And this training period and this teaching period under the UK education like has been very like impactful on me, I'd say, because like during my LLB honors, I got to learn how to think like a lawyer, and during the bar course, I learned to know how to be a lawyer. So like these two are completely two different things, like how to think like a lawyer and how to be a lawyer. And I also got to learn like practicing law basically involves a thought process. So being a lawyer is basically like is basically looking into the thought process and like developing the thought process and trying to understand the problem that you are dealing with. And then I came back to my home country, Bangladesh, and I started practicing law under the supervision of my father, Mr. Khan Saifur Rahman. And he was a senior advocate of the Supreme Court of Bangladesh. And I learned a lot from him as well. And this learning was completely different as well. And I got enrolled in the like Bangladesh Bar Council, in 2009. So in 2009, I got the license to practice law under two different jurisdictions, the UK and the Bangladesh. And these two different legal systems gave me two different sets of thought process. And I got to learn about two different legal systems, which really helped me a lot to understand what law is and how law should be applied in practice. And I got to learn a lot from my father and his law firm, and he was involved in the conduct of many like landmark cases of the country. And even though it was a bit much for me to get involved in those sorts of landmark cases in the very beginning of my career, but that helped me a lot as well to understand how to handle big cases, how to deal with big cases. So like this is how I started my practicing career. And in 2013 I got enrolled in the High Court Division of the Supreme Court of Bangladesh. And like this is my practicing career. And so far as my academic career is concerned, from the very beginning I was involved with the teaching profession. So like since 2005 I've been teaching British law to the Bangladeshi students. And right now I'm the managing partner and vice principal of Newcastle Law Academy West, which is a recognized teaching center of the University of London, based in Dhaka, Bangladesh. So I've been teaching law as well. So I enjoy teaching as well, and I enjoy practicing as well. And I believe that these two things have helped me a lot to develop my thought process further. And I always believe in constant growth, because like this profession is all about constantly growing. Because like no matter how many years have you practiced, you'd always be learning, and you'd always have to have this mental setup within yourself that like I would have to learn more, and I would have to get involved more with the problems, and I would have to be like thinking about solutions. So like this profession is basically a profession where your thought process would have to be developed in a theme that you can solve problem. So like problem would be there, and like you would have to solve those problem. And like this would help you in real life as well, because like in real life we also deal with problems, and like we'd have to adopt a solution based problem rather than a problem based approach to every solution. We'd have to look for a solution for every problem. So like yes, that's pretty much my journey in short.
Thank you so much, Mr. Adnan, on throwing light on your journey. Uh, can you please tell us about your most memorable case and what are your key takeaways from there? Because after that, we will move on to your specializations as well.
Yes, actually, every lawyer has got like some special cases in his career, and like what makes a case special depends upon the facts of that particular case, upon the judgment, and upon its social impact as well. So it's very difficult to identify any particular case in the career of any given lawyer. But like so far as I'm concerned, if you ask me that question, I would say like I have dealt with a pretty important case, namely Tariq Masud and Mishik Munir case back in 2016-17. And that case, so far as my journey is concerned, is one of the most important cases in my career for so many reasons. That's the case where two renowned media personalities died out of a road traffic accident. And over there, a criminal charge was basically brought against the driver who was driving the bus that hit the microbus that was carrying the passengers. So, like, the case was basically a criminal case in the garb of tortious form, because, like, in our country, tort law is not very explicitly recognized. So, like, this was a criminal case, particularly in the garb of a road traffic accident case. And in the advanced jurisprudence or in the advanced countries, the advanced legal systems, road traffic accidents cases particularly fall within the area of tort law. So, like, firstly, that was a criminal case, and I was being approached by the wife of Mr. Tariq Masud, who was a world-renowned media personality in Bangladesh. So his wife, Catherine Masud, she approached me, and I took the case back in 2016. And I was engaged as a private prosecutor prosecutor. I was assisting the prosecution. And in 2017, the verdict came out, and the verdict was a guilty verdict in our favor. And the driver who was driving the bus was sentenced to imprisonment for life. And to the best of my knowledge, this is the first case of its kind in the history of subcontinent where the defendant was convicted with the imprisonment for life sentence for driving his vehicle negligently. And in that case, I had to come up with several arguments to win the case, because the trial judge, the trial court was facing some problems, because like this was a kind of case with which the trial court was not familiar. As I have told you, like these types of cases um, are not that much familiar, or our courts are not familiar with this sort of cases. So like the main argument that I had to put forward was basically like, if you can kill a person with a gun or a knife, then obviously you can kill a person with a vehicle, with a bus, with a car. So like, so far as intention was concerned, that was the major issue. That was one of the major issues in the case. Like, can I intend while driving that like I'm going to kill someone? So like, I was able to establish the proposition that yes, when I'm driving my vehicle in a manner as per the facts, which indicate that I might hit someone, or like I might hit some other vehicle, and I might cause a fatal accident. Obviously, maybe I do not know who am I going to kill, but obviously I surely do know that obviously I'm going to kill someone. So like, this is a case where like this argument was being accepted by the trial court so far as the intention was concerned. And the trial court said yes, the intention was there on the part of the convict driver so far as the killing was concerned. And like, this case does have many important dimensions, and I would like to briefly point out some of them. The first thing is like, in this case, through this Tarek Masood case, tort law got developed under the garb of criminal law, which is very important. As I have told you, like in Bangladesh, tort law is not that developed. So like, it requires development because this is civil wrong. So when someone is suffering from civil wrong, he or she should have the right to go to the court. And if the law is not that developed, then I would not be able to successfully plead my cases before the court. So like in this case, the law of tort somehow got developed in the garb of criminal law, and this is a matter of research, obviously. And the second most important thing is like that in Bangladesh, around 25,000 people die out of road traffic accident every year. So like, this is a major social issue, and this case got a major media attention, not because of the fact that like very renowned media personalities were involved, but also because of the fact like they were internationally recognized. So like, this case accepted huge media attention, and the government had also to look into the facts and the judgment of the cases. And you'd be happy to learn that like, the verdict came out in 2017, and the government enacted a laws in this respect in 2018, which was a huge victory for us, I would say. Like, we had a law in this respect, that is like motor vehicles ordinance, that was passed in the year of 1983, and that was very much outdated, and that required amendment. The government, after the verdict came out, changed that complete law, repealed that motor vehicles ordinance of 1983, and enacted a completely new law in this regard, which is the Road Traffic Accident, Road Transport Act of 2018. So, like, after the verdict came out in 2017, the Parliament repealed the old 1983 law and enacted this new law, Road Transport Act of 2018, and this is a landmark law in our country. So like, so far as the impact of the case is concerned, if you think about the social impact, it did have a huge social impact. And if you think about the legal impact, it did have a huge legal impact as well, because like that resulted into the enactment of a new statute in our country.
Thank you so much, Mr. Adnan, for answering that question. Now, having talked about your most memorable case and also your key takeaways, I would really like to ask you one question, which is often asked. That how do you look at arbitration and mediation in 2021, and how do you think it is going to bring changes maybe 5 years down the line? Because considering it is, one of your specialization, so I'm asking this question.
Actually, when you're talking about like arbitration and mediation, the first thing to understand is like these are forms of ADR, alternative dispute resolution. So like this alternative dispute resolution system, if you want to develop this sorts of ADR mindset of the people involved in the process of litigation is very important. Because like before we move on to the aspect of ADR, it's important to look into the aspect of litigation. So far as our Bangladeshi legal system is concerned, we have an Arbitration Act of 2001. We did have an Arbitration Act in the year of 1940, but that was very much outdated. So Parliament enacted its own Arbitration Act in the year of 2001. So if you look into the effect of the Arbitration Act of 2001, right now we are standing in the year of 2021. So 20 years have gone by, right? So even after the lapse of 20 years, I would say like the laws of arbitration and the laws of mediation and their application have been very limited in our jurisdiction, mainly because of the mindset, because like our people, the clients of this country, are basically they're basically eager to take their cases to the courts. They are basically eager to go to the courts and settle the disputes by the courts. And like in our like civil system, we do have an adversarial procedure where the parties are in control of the dispute. So it's causing what? It's causing delay, cost, complexities, and all the problems are there. But if they had been thinking like, okay, I want quick disposal of my cases and I want to solve my cases through experts and I would like to avoid the complex litigation system, then obviously they would have gone for arbitration. The problem basically in this area is like lack of expertise, I would say, because like the law firms that are dealing with most of these disputes, they do lack expertise in the area of ADR, because like you might be a very successful, very good like litigation lawyer, but you might not be a good ADR lawyer, because like when you're a litigation lawyer, your mindset is completely different, and when you are an ADR lawyer, your mindset should have to be different. You must be ready to negotiate your dispute. You must have the mental thing within yourself that you want to resolve the dispute, maybe over a cup of tea or maybe over a cup of coffee, and like you would like to really settle the disputes. That mentality is lacking, I would say, in most of the cases. And like one major problem I would say is like that lack of arbitration clauses in the commercial disputes. If the in the commercial contracts, so in the commercial contracts when they're being drafted, it's very important that like they're being drafted by the lawyers who have got expertise in the area, because those sorts of expert lawyers would incorporate arbitration clause in those commercial contracts. But this is lacking in our country. So this is one of the major reasons for what, like in 2021, I would say like the law of arbitration and mediation in this country, in Bangladesh, is not that developed that it should have been. But if we look down the road after like 5 years, what I can see is like Bangladesh is raising, or like Bangladesh is getting like recognition from the whole world so far as economy is concerned, and the economy is getting developed of this country pretty fast. So like many companies are coming, and many multinational companies are coming. They're investing in Bangladesh, and we are having so many projects right now in the country, in the city, and in the urban areas as well. So like obviously disputes will be there at some point of time. And like these multinational companies, I would say, they are more willing to resolve the disputes by ADR, and like they're looking for experts in the area of corporate laws. So they are looking for expert law firms, and they're going to them. And like these lawyers, they are advising this like big corporate giants, mostly from abroad, to draft their contract in a line so that like arbitration clauses are there. So like if these arbitration clauses are there, and like if you open up the opportunity for taking a dispute to the arbitration panel, obviously I would say like down the line we would see a very developed arbitration procedure in Bangladesh. But right now, what's the problem is like arbitration is a form of ADR, that's like alternative dispute resolution, and it has become in our country as if like it is like additional dispute resolution to some extent, like because like this is not solving problems, this is mostly adding problems in some respects. The domestic courts are interfering with the arbitration proceedings, which is not acceptable. And like if you look into the arbitration systems of the advanced countries, you see like arbitration proceedings, they are completely separate from the traditional judicial proceedings. So in this country, what we are seeing is like that the judicial proceeding, the judicial courts, they are sometimes interfering with the arbitration proceedings, which should be completely separate, which should be completely independent. So like if these things if these things can be developed, I think that obviously down the road after like 5 to 10 years, arbitration has got a very bright future in this country.
And with that being said, Mr. Adnan, what type of pro bono legal works do you do?
Okay, pro bono. So far as pro bono work is concerned, again, this concept is not that well recognized in this country. When I received my education in the UK legal system, I came across this concept called like pro bono, and like I was quite interested into the concept, and I was looking into like what pro bono is. Pro bono is basically a thing like when a lawyer like discharges his legal duty without charging any fees. So like if a lawyer feels like okay, he or she is socially responsible and like he or she does have some responsibility towards the society, in that case sometimes he can take up cases which does have social implications, and that lawyer can or may not charge any fees in respecting those legal works. So like these types of works are being known as pro bono. So like so far as my legal career is concerned, I have been involved in some pro bono works, and like I have basically chosen two areas respecting my pro bono works. Firstly, I do pro bono works in the area of clinical negligence, and secondly, I do pro bono works in the area of road traffic accidents. And there are reasons for that. The reason is like when I do my pro bono works, I do it purely because of social reasons, and I want to work on areas that do have social implications. As a lawyer, I do feel like I have got social obligations, and I should be discharging those social obligations because, like, the society is giving me so much. So, like, sometimes I would have to work through my profession to give something in return to the society as well. So, like, when I'm talking about clinical negligence cases or when I'm talking about road traffic accident cases. As I've told you, these are all social problems of this country. Around 25,000 people die every year through road traffic accident. And like clinical negligence is another sensitive area because like over here, doctors do not have that much of accountability, and like lives are at stake. So like I'm working on these areas because I want to develop laws on those areas, because this is very difficult to develop laws on certain areas, because like when you're working on the areas of certain laws, the courts already know what the laws are, but when you're working on the development of laws, the courts do not know what you are talking about, what you're arguing. And I think that that's the best challenge that a lawyer can face, because like you would have to make the court understand what you're trying to say. And law is mostly about interpretation, law is mostly about like creating new things. It's not like that you would have to always argue settled principles. You can always try to invent new things, and like you can always think out of the box, and every lawyer should be thinking out of the box for so many reasons while like development of laws is concerned. So like I basically work on the areas of clinical negligence cases and road traffic accident cases so far as my pro bono works are concerned, because I would really like to develop laws on these areas. And if these laws are developed, I believe that the benefit of this development would go to the mass people who suffer a lot.
Well, that was quite an insightful answer, Mr. Adnan. Thank you so much. Uh, Now, when you're actually talking about Bangladesh in a lot of detail and about the law culture there, then how developed is the law of clinical negligence in Bangladesh specifically?
That's a very important question, and like as I've told you, like this is like one of my areas of expertise. Um, to be honest, law of clinical negligence in this country is certainly very underdeveloped, and there are so many reasons for that. The main reason is like when you are working on the areas of settled laws, you can always argue in terms of the settled laws. But when you're arguing for the development of something new, you'd have to make the judge understand like why is that important, and you'd have to give reference. Even if you don't have any reference from your own legal system, you can always bring reference from the like legal system of the advanced jurisdictions, like that of the UK, like that of the United States, like that. I would say like India has got a very advanced legal system as well. So like you can always refer to these legal systems. So like so far as clinical negligence law is concerned, the law is not that developed, and like this is one of the areas where I have been working for so many years. And I would like to point out to a fact, like I have done a case which recently received huge media attention, and that's the Ohana death case. And this case is very close to my heart because of so many reasons. In this case, a child died, a girl died. Uh, she was just about like 4.5 years of age, and she died out of a very apparent negligent treatment from some very well known doctors of the country and a very top shot hospital of the country. So, like, that hospital is also one of the big corporate houses in Bangladesh. So, like, my client, the father of the victim, he tried his level best to save the child, and like he at some point of time he had to discharge that kid from that hospital, that scar hospital, and he had to take his child to Bangkok through air ambulance. And when that kid was taken to Bangkok through air ambulance, the Bangkok hospital said like it's too late, and the treatment that she received in Bangladesh was so grossly negligent that like even if the best effort was given, the life of that kid could not be saved. But those Bangkok hospital doctors tried their level best, but they could only just extend the life of the kid for another 8 to 10 months. But that kid actually died back in 2014. We launched the criminal case in the year of 2015. We also launched a compensation case in the year of 2015, and we did not get proper order from the lower court, we felt, and being aggrieved, we moved our petition before the Honorable High Court Division. And you'd be happy to know that, like, on the last month, that was like February, on the 23rd of February, the High Court Division bench, like comprising Mr. Justice AKM Abdul Hakim and Mrs. Justice Madam Fatima Nazib, they gave a very remarkable judgment in the area of clinical negligence, whereby they basically send the case to the lower court so that the case can further proceed. So, like, so far as the lower court judgment was concerned, the case was flawed so far as the Ascar Hospital was concerned. But the High Court Division in the judgment said that no, this is a case of clinical negligence. The law should have to be developed in this regard, and the complainant could show enough materials on record, and so this case would have to go to the trial, and the accused discharged in the case would have to face trial. So this has been a very remarkable judgment in the history of Bangladesh against so far as clinical negligence is concerned. And and I would like to add one more point, that is like our appellate division, our Supreme Court, has told in many cases that the lower courts have the power to create new torts, like clinical negligence or road traffic cases and so on. But our lower courts are not showing that much like judicial activism so far as these laws are concerned. So like as I have told you, like development of these laws is very important if you consider the impact of these problems on the society at large, because like lives are at stake, and like people might lose their child, people might lose their parents if they go through a negligent treatment, or if they go through a fatal road traffic accident. So even though the Supreme Court of this country has explicitly stated in a number of judgments that the lower courts are at liberty to develop tort law, to create new torts, but our lower courts are not showing that much much of judicial activism. So that's one of the areas where I've been working, because like I would really like to see the total of this country being developed, because in that way we can have a real impact in the society.
Thank you, Adnan, yet again. Now, this was about the law of clinical negligence. What about the challenges that one faces when it comes to corporate law practice in Bangladesh?
As I have told you, like corporate law is getting developed in this country as well, because like the economy of this country is getting developed. Many people are investing, and we are getting many foreign investors who are willing to invest in Bangladesh in different projects, and we are having huge projects, $1 billion projects, and so on. So like the challenges are basically manifold, but I would like to make it very short, so that like everyone can understand. One of the major challenges of corporate law is like that, in this country, the huge companies, they're basically family companies. So when you are family companies, what happens is like you don't want to make your company legally compliant. They're spending huge money behind the infrastructure, behind developing the corporate structure and so on, but they don't have that much of budget to do the legal works of the company. And another major problem is like that we have got RGSC, that is the Register of Joint Registered Companies and Firms, which is the regulatory authority in this behalf, but they don't have that much of human resources, and their human resources are not properly trained. So like they are not being able to observe whether or not most of the companies in the country are being legally compliant. So like this is a major problem, because like you would find so many companies, so many family companies that are not holding annual general meetings or board meetings or even audit, because like as I've told you, like they are being run very informally so far as the like managerial aspect is concerned, because most of the owners are like brothers or like parents, children, and so on. So like they are running very huge company, but so far as the like internal structure of the company is concerned, the internal structure is not legally compliant so far as the company law is concerned. So like this is a problem with the lack of awareness, I'd say. And like so far as the corporate governance is concerned, I would say like this concept is very poorly developed in this country, and like it should be developed, because like the corporate or the big corporate houses, they should not be beyond accountability. They have got their accountability towards their stakeholders, and like I am also one of the stakeholders, you are also one of the stakeholders when you are buying products from a giant company, right? So the safety of the product, or the quality of the products, these are all very important factors, and these factors might affect the consumers at large. So like if we cannot like develop the system of corporate governance within the legal system, I would say like this would be not a very good thing for the future. And like companies have got accountability towards ensuring environment safety as well, because like global warming is one of the major issues. And if the companies are not compliant so far as the environment laws are concerned, in that case environment would be directly affected. So like these things are all major concern, I would say. And over here I would say like the mindset is very important. And if you look into the corporate law framework, you not find that much of law firms having expertise in the area, but they have got big names. Because like in this country what happens is like when a lawyer is like politically renowned, or a lawyer does political activities, he becomes renowned. So like you become renowned does not make you an expert in that field. So like many companies are running after the renowned lawyers because like he is very politically active, or like he's very politically influential, but that doesn't make him an expert in the area. So like lack of awareness is again a problem. The companies should have to like understand that like we'd have to look for expertise, not name, not fame, because in this country you can earn name, fame through your political activities, and law has nothing to do with politics. Law is completely different. This is a matter, or this is an area where knowledge should be given a priority, and where expertise should be given priority. So like I believe that like lack of awareness, lack of expertise, these are all affecting. And the other thing that I have told you, that the companies should understand that like the importance of ADR is very important, because like rather than going for the traditional litigation system, if the companies think, okay, we can resolve our disputes through like arbitration or mediation, in that case a loss of resources, a loss of times can be saved, and through that many benefits can be got. So the companies should be like developing their mindset. So I would say like the problem is basically associated with the mindset. The mindset would have to be developed. If the mindset can't be developed, then obviously I think that that will affect all of us.
Thank you so much for sharing such great insights with us, Mr. Adnan. I'm sure your experience and your knowledge is going to help a lot of people who are going to watch this interview. We really look forward to having a chat with you again in future on some other trending topics in the international legal industry. And for our viewers, if you like this chat with Mr. Khalid Adnan, please like and share this video and also subscribe to ClickAway Creators YouTube channel to appreciate what we do, and you have more coming from industry leaders. And how would you get to know that? By pressing on the bell icon so that you do not miss out on any video. This is Bharti for LexTalk signing off. Take care. Bye bye.